A lot has changed because of the Supreme Court's recent orders denying multiple assault weapon and magazine ban cases, so we need to break down what is happening. Now, really quick before we jump into this video, I want to mention once again that we do have a newsletter available. You can find links to it down below in the details section and then also in the pinned comment. A lot of you already signed up for it, so thank you guys so much for all of your support. And one of the things I want to mention is that probably when we hit about 5,000 members on the newsletter, not only are you going to be getting articles, news, deals, and all of that, but we're also going to be running monthly giveaways just for the members who are in the newsletter. So if you want to be part of that, make sure you sign up. And again, links are down below to the newsletter. Also, I want to thank one of the main sponsors of the video, which is Kershaw Knives. Kershaw makes some of the best knives available on the market if you're looking for a quality EDC knife. I carry the Kershaw Iridium knife every single day for my EDC, and I cannot recommend them enough. So if you're interested, check them out by going to Kershaw's website, and if you use the code ARMED40, you can get 40% off of your order. Now, like I mentioned in the intro, in this video, we need to talk about what is now happening with the multiple cases that are out there challenging the state of Illinois' ban on so-called assault weapons, and then also the magazine ban that they put in place. Last week, we received news from the Supreme Court in their order list that they have in fact denied review to multiple cases which were challenging that Illinois rifle and magazine ban. In that order, only Justice Alito was interested in granting immediate interlocutory review to those cases, but we did receive some statements from Justice Thomas on the same topic. The statement from Justice Thomas indicated that many of the justices believe that this topic here about rifle magazine bans is in fact very important and that the Supreme Court needs to address this issue sooner rather than later. But also from that order, it appeared that the majority of the court simply did not want to get involved in this case because they were still dealing with an appeal of a preliminary injunction instead of a final merits decision. And the Supreme Court likes final merits decisions, and that's also what they indicated in that statement from Justice Thomas. Now, you might remember that in a lot of these cases, a district court issued a preliminary injunction that was intended to halt the enforcement of PICA until the court there could reach a final merits decision. That came from Judge McGlynn, and Judge McGlynn outlined how he believed that the plaintiffs were in fact likely to succeed on the merits of their claims, that the state of Illinois and their rifle magazine ban was in fact a violation of the Second Amendment. However, of course, the state of Illinois appealed that injunction up to the 7th Circuit, and on review, a liberal and biased 3-judge panel in the 7th Circuit overruled his granting of that preliminary injunction. The analysis that they used in the 7th Circuit and the 3-judge panel there, that analysis did not align at all with Heller's common use test or even the recent Bruin holding about text, history, and tradition. Instead, the 7th Circuit 3-judge panel concluded that the arms protected by the Second Amendment do not include weapons that may be reserved for military use. So the 7th Circuit 3-judge panel there used the military use test. Then in reaction to that horrible decision, there were multiple calls for the 7th Circuit en banc panel to review these cases. However, the 7th Circuit en banc panel denied review to all of these cases. That then led again for the plaintiffs here to seek immediate Supreme Court review, immediate intervention of those preliminary injunctions. But like I mentioned, the Supreme Court at the end of their term denied review to all of those Illinois cases. Now, in that denial, Justice Thomas stated that the state of Illinois enacted a law that makes it a felony to possess what Illinois branded assault weapons, a term defined to include AR-15s. The AR-15 is the most popular semi-automatic rifle in America and is therefore undeniably in common use today. And there, interestingly, Justice Thomas is quoting directly to Justice Sotomayor in the Cargill decision when she said that AR-15s are undoubtedly, in common use today. So that was also very important. And then he goes on to say that the petitioners sought a preliminary injunction against the enforcement of the law, arguing that the law violates their Second Amendment right to keep and bear arms. The Court of Appeals for the 7th Circuit rejected the petitioner's request for a preliminary injunction, concluding that the AR-15 is not protected by the Second Amendment. According to the 7th Circuit, the rifle selected by millions of Americans for self-defense and other lawful purposes does not even fall within the scope of the arms referred to by the Second Amendment. This court is rightly wary of taking cases in an interlocutory posture, but I hope we will consider the important issues presented by these petitioners after the case reaches a final judgment. We have never squarely addressed what types of weapons are arms protected by the Second Amendment. To be sure, we explained in the DC versus Heller case that the Second Amendment's protection extends prima facie to all instruments that constitute bearable arms, even those that were not in existence at the time of the founding. And we noted that the Second Amendment does not protect those weapons not typically possessed by law-abiding citizens for lawful purposes, recognizing the historical tradition of prohibiting the carrying of dangerous and unusual weapons. But this minimal guidance is far from a comprehensive framework for evaluating restrictions on types of weapons, and it leaves open essential questions such as what makes a weapon bearable, dangerous, or unusual. The Seventh Circuit's decision illustrates why this court must provide more guidance on which weapons the Second Amendment covers. By contorting what little guidance our precedent provides, the Seventh Circuit concluded that the Second Amendment does not protect militaristic weapons. It then tautologically defined militaristic weapons as those that may be reserved for military use. The Seventh Circuit's contrived non-militaristic limitation on the arms protected by the Second Amendment seems unmoored from both text and history, and even on its own terms, the Seventh Circuit's application of its definition is nonsensical. In my view, Justice Thomas states, Illinois' ban is highly suspect because it broadly prohibits common semi-automatic firearms used for lawful purposes. It is difficult to see how the Seventh Circuit could have concluded that the most widely owned semi-automatic rifles are not arms protected by the Second Amendment. And here's the warning that Justice Thomas included in his statement. He states that, but if the Seventh Circuit ultimately allows Illinois to ban America's most common civilian rifle, we can and should review that decision once the case reaches a final judgment. So although the Supreme Court denied review to all of these cases, Justice Thomas, through his statement, stated that the court there is very interested in reviewing a final merits case that deals with this type of topic, with a state's ban on rifles and magazines. And he also sent a warning to the Seventh Circuit that on a merits review, if they get this case back and they uphold this broad ban on rifles and magazines, banning the most common, rifles out there that are used for lawful purposes, he sent a warning that the Supreme Court probably at that time will in fact grant review to this case. They just want a merits decision. Now, also while this whole preliminary injunction appeal was going on and went up to the Supreme Court, the lower court judge there, Judge McGlynn in the district court, he was deciding to move these cases along as fast as possible, and he was moving them towards a final merits decision. Judge McGlynn held a conference on multiple of these cases, on all these PICA cases, and he said pretty much that he is going to fast track them and not put them on hold. Now, also recently, Judge McGlynn moved one of the conference dates because of that looming order list when we were anticipating maybe the Supreme Court would grant review to this because, it was being moved multiple times. A lot of those cases were rescheduled multiple times for conferences, and a lot of people had some questions about what the Supreme Court was going to do, and then ultimately it seemed like there was some debate on the Supreme Court about granting review to these cases, and then we got that statement from Justice Thomas. And now that the Supreme Court has denied review to these cases in that recent order list, all these lower court cases are going to move towards a final merits decision and a bench trial that is currently set for September 16th of this year. So September 16th is the date we're going to be looking towards for a hearing on the merits. That means probably around October-ish or maybe even November, we would get a final merits decision in all of these cases. Now, also at the same time, I want to note that we probably should also be watching all the cases that are a little bit further along in the process now the Supreme Court is wanting a merits decision. We would be looking at California in the Duncan versus Bonta case, which deals with magazine bans coming out of California. That is currently just simply waiting for an en banc panel ruling. There was already an en banc panel hearing back earlier this year, and now we're just waiting for a decision. And then also the Maryland Bianchi versus Frosch case that deals with the state of Maryland's rifle ban using a similar analysis known as the military use test. The en banc panel in the Fourth Circuit has already heard that case, and we're simply waiting for a decision. So both of those cases deal with similar issues, rifle and magazine bans, and they're further along in the process, merits decisions that the Supreme Court wants. So I think those maybe are going to beat the Illinois cases to the Supreme Court probably during this next term. But for those of you wondering what is going on in Illinois and what is the reaction and what is the path forward after the Supreme Court's denials, that is what's going on. We are going to move towards a final merits hearing on September 16th. And if anything else changes, if anything else develops, I will let you guys know. So if you guys like this video and you would like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. But as always, thank you all for watching. Don't forget to like and subscribe, and never forget this nation was built by armed scholars, and this nation will be maintained by armed scholars.